Good evening and welcome to Undoing I Do with Stephanie and Aday. I am Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey, and your co host for this evening.
And I am Adelola Sherilyn Dow, the owner of the law offices of Adelola Sherilyn Dow in Staten Island, New York. Stephanie, it's Thursday
Yay!
again.
It is
Hey!
Thursday. These Thursdays keep sneaking up on me for some
It just
reason.
that's how you know you're getting old. Well, I'm just going to speak for myself. When I came, I had my glasses and everything. Got
Oh, me
my,
too. I need them. I can't see. I can't see.
I couldn't see today. I don't know
And
what
then I
was
have the
going
ring
on.
light so I could see the little ring in there.
Oh, yeah, I see
Which
it.
is like a little frustrating, but whatever.
Child, just give my specs a little bit of a showing, and then I'm just going to be paying to take them off. Hmm.
I'm literally so blind I wouldn't be able to see you, so I have to keep them on if I don't have my contacts in.
Oh my goodness. I am so happy to talk to you this wonderful Thursday in the frigid cold. I don't know what happened, but I'm just glad it's not snowing.
Oh my
The
gosh.
little pretty snow that we had last week was awesome, though. That was gorgeous. It looked like a little card,
That's funny
Christmas.
because this morning I just said, "Oh God, I wish it would snow," and then I was like, "What happened to that California girl? What? What?
Yeah,
Why do I
where
want
is she?
snow?"
Where is she? Because this winter, even though we really haven't been in it for long, it just seems like so long. And probably because of the whole COVID effect and everything.
Yeah, I think it's just because it's been a really, really long year in general. So I think, yeah, I'm ready for, well, I'm always ready for winter to be over because I do prefer the warm weather.
Yeah, I need to be outside again, but that's all right. In the meantime,
In the meantime,
we got some goodness to give to people today. Yeah, this is one of those topics that sets people off, so we're just gonna do it.
yep, yep. And also, I think this topic has a lot of value because we're talking about when you have to pay your spouse's counsel fees.
Mm, mm. Yes, that's the thing. Oh boy, we're gonna get juicy tonight. Yes, sometimes you will be in a situation where if you make more money or if you do something naughty, you have to pay counsel fees. And not the good naughty, but So,
That's getting paid for something else.
right, that's a whole nother show. That's a whole nother show. But yeah, there are going to be times when if you're in a divorce or even if you're in a family court proceeding, at least in the state of New York, where you may be called upon to pay counsel fees of the opposing party. And I will tell you that when I represent what we call in New York the moneyed spouse, this is always an issue. Sometimes we can get you out of it, but that's why you need to stay tuned to figure out how.
Yeah. And I want to say, and I think New York is probably a bit more generous with counsel fees. I find, and I have over the years, there's little ebbs and flows with certain judges, but I find most of the judges from like Central and South New Jersey, especially, are very hesitant to order counsel fees. When you're in northern Jersey, you get a little more, I think, of the New York flavor and an understanding that counsel fees are necessary. It's not necessarily a punishment. When you have a spouse that earns more and then you have a spouse that doesn't earn more. So that's one of the, a little bit of a shift from, New York to New Jersey, I think.
Yeah, so in New York, we have this presumption in our statutes that the moneyed spouse is to pay counsel fees. Now, that presumption came about in 2010. I'm so sorry. It's so hard to believe that that has been an 11-year-old change
It's like
already. I
5 minutes.
don't. I was in my 20s when that came out. Lord, what's going on? But anyway, there's a presumption that if you make more money than your spouse, no matter whether you are a a husband or a wife or what your position is in the case, there's a presumption whether or not you're a defendant or a plaintiff that you will pay the counsel fees of the party who doesn't earn as much money. Now, sometimes people say to me, oh, but they filed the divorce. Mm, that's not going to work. It doesn't really matter whether you are the plaintiff or you are the defendant. Plaintiffs get counsel fees paid by defendants all of the time.
Uh-huh. And we've talked about that. There's really not much of a reason for it to be a plaintiff or defendant as far as strategy goes, except when it comes time for trial, because then you have, to go first or go second,
Right.
depending on whether you're the plaintiff or the defendant. But yeah, just because you're titled plaintiff or defendant doesn't mean one person did something wrong and the other person didn't and has to pay. Yeah, that's just not the case for divorces.
Yeah, no. The plaintiff is simply the person who ran into court and filed first.
Right.
That's all. And, the other thing that people sometimes think of is, oh, well, that person has money. They have a fat bank account somewhere, or they have an inheritance that they can pull money from in order to pay their counsel fees. Why should I have to pay? Well, our case law in the state of New York says that the non-moneyed spouse, the person who's claiming not to have as much income as you may, does not have to exhaust his or her own resources in order to fund the litigation if there's going to be litigation. So if you say to your attorney, oh, but they have $50,000 sitting in the bank that's just, collecting dust, and your attorney says to you, oh, okay, definitely, we'll tell the judge that they can pay using that money. Yeah, that's probably not going to be a long term successful argument unless something else comes up in the case that requires that money to be tapped.
Right, and I want to just backtrack a little bit because we're really talking about what we call pendente lite counsel fees. So these are counsel fees that are designated during the course of the litigation or during the pendency of the litigation is really what it stands for. And in New Jersey, there's something very similar with not being required to get rid of all of your equitable distribution or dissipate all of your equitable distribution just because there is some when there's a high earner that's on the other side of your case. So if, for example, the high earner spouse earns 300,000 and you've always been a stay-at-home mom and don't really have a job, they're still going to likely make the moneyed spouse, the high earning spouse, pay some of your pendente lite counsel fees. There's not any presumption that that's going to be the case, however. And I've seen trends over the years. So, for example, when we were having the trend when the housing market was going crazy and everybody's house was worth a lot of money, judges were ordering people to go out and take home equity lines of credit and giving each of the attorneys on both sides, plus whatever experts were required, counsel fees. So you were using your house to pay your legal expenses.
Yeah.
And that was that one period of time where I saw that there was really a latching on to assets in order to cover counsel fees, even when the people made enough money that they could have paid counsel fees through their
Yeah.
income.
Yeah, those were the bad old days. Like that was like the 2000 early 2000s.
Mm-hmm.
I remember when I was clerking in 2006, 2007, that was a very routine type thing that was done where people would tap into, judges would order people, yeah, go ahead, take a second on your house, take a home equity loan, do whatever it is, get John and Jamie paid, and then go on with your litigation. What was interesting about that is that it would almost never be reallocated to the other, to either other of the parties. So when you say something is going to be reallocated, that means that a judge later can determine that your spouse will be responsible for more of that debt, or that you would be responsible for more of that debt, as opposed to it just being a 50-50 split. And,
Right.
I will tell you that sometimes that backfired. Sometimes that made these cases a little bit dangerous because people were thinking as though they were almost playing with like monopoly money. It wasn't really hurting them.
Mm-hmm.
And I'm going to tell you, a lot of times judges use counsel fee awards, at least in the counties and parts that I practice in front of. A lot of times they use those counsel fee awards as almost a little press to get the person paying the counsel fee award
Mm-hmm.
to settle out the case.
Uh-huh.
You don't have that type of impact when people are using their home equity to pay counsel fees.
Right. And I think during that time, I have to say, the awards were very freely given. Council fee awards were very freely given. It was a very strange time, completely different from what we've experienced before that and what we experienced after that. Um, And I agree with you. I think sometimes it made it more difficult to settle a case because you had this little pot of money that you're able to litigate and fight, and it didn't feel real because you knew that you still had this, extreme value of your house that you were able to you're gonna still sell it and still make a profit. So people were exactly, it was like monopoly money. I 100% agree with that analogy. And it did make it more difficult sometimes.
It's depending, especially depending upon who your adversary was on the other side of the
Yes.
case. So there
Um,
would be situations where people would just be like, "Oh, okay, well they have the money, so guess we're going to do this deposition. Guess we're going to do that. Guess we're going to do the
right.
other."
There
And
were
that's where
some definite churners that
some
that was
shady
happening.
folks,
Mm-hmm.
mm-hmm, some
Yep.
shady folks where that was happening. You know what? In all my years of practicing in New York, that really never took on. It was never really a thing, right?
Okay.
People would never, judges would, and I have not really seen that. I can't say that I've seen it with such prevalence where, judges would just out and out order it. It may be that parties came to a solution whereby neither one of them could afford these counsel fees,
Mm-hmm.
but they had to go ahead and tap the equity. And then in those situations, the attorneys were holding the money, and it was probably not only being used for counsel fees, but probably also for forensic evaluations and things like that.
Mm-hmm.
I have seen more so where judges will allow people, at least in New York, to take out distributions or loans against their retirement benefits to pay for the litigation. I've seen
Right.
that more so than, the whole equity on the house thing,
Right.
which, these days doesn't really work as well.
Right.
Most likely because people have, already stripped out the equity of their homes, right? Or
Mm-hmm.
because they've, recently gotten into the homes and don't have enough equity anyway.
Right. I mean, and there was also a big explosion in a short amount of time of property values that were
Yeah.
artificially being inflated. So that
Mm-hmm.
had something to do with there being this extra surplus of money in a house that there might not have been before. I have,
Exactly.
yep, and I have seen in the normal course where people cannot afford counsel fees, but they really need it because they have a custody issue and they need a custody evaluation, or there's a business and they need a business evaluation, but they don't necessarily have the cash flow. It is one or both of the parties will ask the court to be able to use pieces of the pieces of property that are subject to equitable
Right.
distribution in order to pay and fund the litigation. That's not unheard of. It happens, and sometimes it needs to happen because not all cases can just be resolved through a quick exchange of case information statements and that kind of a thing.
Yeah, and so then the question becomes, all right, so now I have this counsel fee award. How the hell do I pay it? Right? So again, some judges will let people take money out of 401ks. I've been on cases where um my clients have had to completely liquidate an annuity or a 401k
Mm-hmm.
and do an advance on equitable distribution in order to get counsel fees paid out. And then, even in order to get some other stuff paid out, maybe there's repairs to be made on the house, or maybe
Mm-hmm.
one of the parties needs to set up a new residence and they don't have the funds to do that, or maybe they need to get a residence out of foreclosure. That's
Mm-hmm.
happened as well. But if that's not your case, or if you don't have a 401k or an annuity, I'm going to tell you that one of my biggest pieces of advice before people even start to get into big litigation, if somebody comes to me with a case and I'm like, there is absolutely no way that you all are going to be able to settle this, you are going to need litigation.
Mm-hmm.
One of the first things I say to them is, how's your credit? Do you have money? Have you been putting money to the side? Is there anybody who can lend you this money? Because I will say that if you get a counsel fee order and you go before the wrong judge and you decide that you're not going to pay that counsel fee order, some of these judges will be holding you in contempt. So before you get into this situation where you may be the person who's paying these fees, you're going to want to make sure that you're somewhat set up for at least several months of expenses.
Yep. I early on I had a case that I was kind of thrown into. I was practicing for under a year, and I was supposed to go to this hearing that I knew 30 minutes before I was like out the door to go to this hearing. So I show up in court and I'm making the best arguments I can make. But the judge was like, your client's getting arrested and you didn't pay and it was over counsel fees because there was a PL counsel fee. The judge and the other side made a very good case that he had the money and was just opting not to pay. So they ordered him arrested, and he was arrested on the spot while we were there. And then he had to come in with, they processed him out pretty quickly with the understanding that he would come back within like 24 48 hours with the money, and he did.
Yeah,
But yeah, so you can get arrested and they don't necessarily release you as quickly as they did him. They can keep you for, until it's no longer a coercive measure.
that's right. Yeah, and so in New York, and I think it's the same time frame in New Jersey. In New York, technically, they can keep you for up to 6 months, right? Because then it's not coercive. If you haven't paid this money in 6 months, it's not coercive.
Right.
I've never seen anybody do it. I've seen people get arrested. Thankfully, not my clients, because I usually tell people, listen, you better come up with that money because it's not cute getting processed, even if they're going to send you out, even if you're going to leave,
Yep.
within an hour, 2 hours, 24 hours. Why go in the first place?
Yep.
you know?
Exactly.
And so, yeah, there are some judges who will not hesitate.
Mm-hmm.
And if you are lucky, they will need room
Mm-hmm.
at the detention center for people who have committed actual crimes, serious
Mm-hmm.
crimes, and you will be free to go. But I'm not trying to listen. No, I'm not trying to darken anybody's, jail doors. I'm just not on the other side. I'm just not.
Now, I
Mm-mm.
think I told you this story on another show or another episode. So it's not really related to counsel fees, but when I was a law clerk, my judge did have a gentleman arrested because he wouldn't pay his alimony. And my judge brought him back every like couple days, then a week later, and then like a couple days later. I brought him back multiple times, and he was adamant, I will not pay. And so he was trying to okay, tell you what, if you can give me $500 to, we'll let you go. I will not pay a dime. I will sit in jail and I will not pay a dime. And at that point, I think the judge brought him back one more time. But at that point, there was nothing he could do because it wasn't coercive, and you can't punish somebody for not paying. It's just a matter of trying to get them to pay. So, yeah.
Right, right. And so now that's not the thing to do, right? Because
No,
my
no.
judge would have people locked up all the time. My judge, he did not play. Oh
No.
my gosh. May he rest in peace. He did not play. And so the thing that people have to remember though is that even if the judge lets you out, the judge remembers
Mm-hmm.
exactly what you did. And if that judge's thought process about you has already been swayed in the direction of you being the problem, not that you don't have money, but
Mm-hmm.
you're the problem.
Mm-hmm.
Judges' memories are long. And so you may get out of jail, but they may sanction you. They may find against you in certain ways inequitable distribution.
Mm-hmm.
So you have to be very careful about that.
Oh yeah, he didn't get away scot free. I mean, he was let out of jail,
Right.
but that didn't mean there were no consequences.
Mm-hmm. Mm-hmm.
And by the way, that also doesn't mean that there is no there's no enforcement mechanism. So the judge, you end up getting a regular judgment that the ex-wife can now go and collect upon. And attach your home and whatever
Impact your
method.
credit.
Mm-hmm. Yep, impact your credit. They can go after your tax refunds. Seize bank accounts. I was
Garnish your
successful in getting
pay.
someone's boat one time.
Was it a nice boat?
No,
Oh, okay. Well,
my
well.
wife was saying it was such a nice boat, and then when I saw, it, I was like,
But yeah, I mean, who wants to come out to the dock and then your boat is just gone, or they attach your car and your car has been impounded or something. I mean, this is not what's up. And so, how do we avoid this? Well, one of the biggest ways to avoid, if you can, having a counsel fee order issued against you is to negotiate that before you even
Mhm.
get into a courthouse. You know, I've had people who sit down with me and say, you know what, I really would like to keep this case collaborative. I don't ever want to see the inside of a courthouse. How do I do that? What are some things that I need to? One of the first things I say is, you already know that you're the moneyed spouse. You
Mhm.
already know that you make 100,000 more, 200,000 more, three times more, whatever. Let's get some of the things that we don't want to be a trigger out of the way. One of those things is counsel fees. Let's come up with a reasonable amount of money. Oh, did you pay me $7,500 as a counsel, as a retainer? Let's let's start out on even keel. You have the money, and you don't want to be arguing about something like that if you don't have
Right.
to.
Right. And you can also, if you don't have the full 7,500 or even 5,000 or whatever it is, you can also work out saying, fine, I'm going to pay you $1,000 for the next 5 months. There's flexibility in negotiation. Once you go into court and the court orders it paid, the court wants it paid in a lump sum unless they order otherwise.
Right.
Um, and for the most part, I usually see counsel fees for PL ordered as a lump sum because they
Yes.
expect you to get the money from someplace because you also got the money for your own attorney.
That's right. That's right. And so you know what? That's a good segue to something that is ancillary to this issue. We have people who call up and say, "But I don't have the money to afford an attorney." Right? Okay. The majority of attorneys are going to say to you, "We understand that. We will go after your spouse for counsel fees." But one of the things that people have to understand is that even if it's a presumption, such as it is in New York, it's never a 100% guarantee. That's
Right.
why it's called a presumption. You may have a judge who says, this case seems like people need some skin in the game. I may not want to, they not may not want to make the moneyed spouse 100% responsible because they don't want the person who's not paying counsel fees to then feel like, they're scot free and they can just whip around and be a hurricane in terms of the litigation. So it may be that they require you to be responsible for 15% of your counsel fees, 20% of your counsel fees, just to make sure that you have a reason to resolve your case. But know that most reputable attorneys will still require you to have some kind of retainer upfront, or they'll require you to pay as you go along, depending upon what their billing practices are.
Right. I actually have written into the retainer agreement that even if your
Yes.
spouse is obligated to pay your counsel fees at some point in the litigation, that doesn't alleviate your responsibility for counsel fees. So it's not my responsibility as an attorney to chase your spouse for counsel fees. I'm going after you, and then you're supposed to be getting the money from your spouse. Obviously, if we're in the middle of litigation, counsel fees are going to be an issue and there's going to be motion practice or something like that. But I
Mm-hmm.
mean, mostly it's after the litigation is resolved.
Right, exactly. And so and where this might also come up is not only during regular pendente lite, which is pending litigation again, if you are just tuning in, but also with respect to enforcement. So if you did something naughty, you didn't obey the orders, you destroyed property, you did stuff that was not in compliance with what the judge wanted you to do or was not in compliance with what you agreed to do, you can have counsel fees assessed against you as sanctions for enforcement.
Right.
And if that is the case, again, maybe you won't have to pay it up front, but your share of the house equity may be reduced, or so on and so forth. There's a myriad of ways that a court can get that money from you or assist your spouse in getting that money from you.
Correct. Yep, absolutely. And if there's also some presumptions with child support. So if you're in arrears in child support and they have to file an enforcement application against you and you win, that weighs in favor of you having to pay counsel fees. So not only are you going to have to get caught up with your child support obligations, you're also going to have to pay the counsel fees of the other side. And the court in New Jersey has a list of, I don't know, like 8 or 10 factors that they consider, which includes, your ability to pay, the amount of counsel fees expended, whether you're enforcing an order. if you filed any motion practice in the state of New Jersey and you've seen your attorney or somebody else put in, they failed to pay child support. And then the next line is find them in violation of litigants' rights for failing to pay child support. That's actually a key phrase because when you're in violation of litigants' rights, it's essentially like a sanction that we're requesting.
Right.
And we're saying that if you are in violation of litigants' rights, then you should be responsible for counsel fees.
Yeah, and a lot of most of our statutes in New York, especially with respect to enforcement, use the word shall.
Mm-hmm.
So it says shall be responsible for, if we're, especially if you're looking at some child support, and it doesn't have to be that you are willfully not paying. So
Right.
you could have lost your job and just not modified your child support obligation, and then kind of ignored the obligation or didn't pay the obligation, and your ex or your adversary can still look for counsel fees, and the case law and the statute says shall. That doesn't mean that they get all of the counsel fees, but it does mean that there's going to be some kind of reward.
Mm-hmm. And in New Jersey, it really is more discretionary for the judge. The judge is supposed to weigh the factors and figure out whether or not, based on all of the factors and circumstances, whether or not a counsel fee award is appropriate. A lot of people will throw in, there is a catch all with those factors. And so, one part of the catch all is any other reason that's appropriate. And we
Right.
throw in bad faith versus good faith. When you brought the application, you thought it was a frivolous application and you made it in bad faith, or you were in violation of an order when you brought in the application. So why should you be rewarded when you were also doing something bad?
Right.
But yeah, so there is some discretion. And I know, at least as a practice tip in New Jersey, some of the attorneys, when we're finalizing your divorce, we write into the property settlement agreement that this is not discretionary. If we have to enforce the judgment of divorce, then counsel fees shall be awarded to the winning party, which takes the may out of the case law that says the counsel fees are appropriate in New Jersey.
Yeah, and one of the things that I've started to do in my agreements is to eliminate the need for a hearing on how much counsel fees should be paid, because then you're going to end up spending more money in counsel fees. So
Mm-hmm.
within my agreements, especially if I think that there's going to be a problem with enforcement,
Mm-hmm.
I put in there shall not be a hearing, because you will have some situations where people will ask for hearings. Oh, well, how do we know whether the amount is reasonable? How do we know whether this, whether they should have paid $4,000 versus $3,000? And then some fool is going to sit up there spending hundreds of dollars an hour
Right.
over $1,000 and whether the $1,000 is reasonable.
Mm-hmm. That's especially true when there's a pro se litigant on the other side because they don't have to pay for an attorney. And so there's not any reason for them not to make their spouse incur more attorney's fees, even
Right.
sometimes just out of spite.
Right. Unfortunately, that is a thing,
Mm-hmm.
whereby, somebody is representing a pro se person is a person who represents themselves, and they say, oh, okay, you want to spend money on this? All right, well, let's do it, and here we go. I'm going to file this motion. I'm going to file that motion. I'm going to file,
Mm-hmm.
this petition and that petition because, hey, I don't have anything to lose, but you do because you keep paying John or Sally or Sue to represent you.
Yep.
That happens unfortunately, it happens all the time. Thankfully, I don't have that going on in my practice and haven't had it going on for a while, but it is a thing for you to be aware of.
It really is. And I actually found some obscure case years ago because it was happening on the it was just a regular thing that says that if there are multiple applications and some unreasonableness, I forget the exact language, but that the counsel fee award is now presumed, and we're against the defaulting party. And at that point, I think the pro se had filed like 5 separate motions and lost them all. So
Ugh.
they finally we were just getting counsel fee upon counsel fee upon counsel fee after that. And of course, you just have to keep reminding the judge what's happening.
Right.
And
Right.
you know, it doesn't make it less expensive for the other spouse because we actually didn't get all of the counsel fees recouped until probably like I said, the sixth application, when the judge was like, all right, you know, we got a couple $100 here, then we got maybe 500, then maybe 1,000, and then we got, you know, the whole enchilada.
And you know what? It's so frustrating for people to have to be paying these counsel fees in order to fight somebody who just really wants to just be in it for the fight.
Hmm.
What kind of advice do you give to your client when they're in that situation?
I mean, it really depends on the facts of their case, and whether or not I think that they can either recoup the money or the money is going to be worth whatever they're fighting over. Because there is times that I've told people, look, we're going to win at the end of the day, but it's going to cost you X amount. So that win is no longer a win.
Right.
And unfortunately, we're then forced to give up something because somebody that was unreasonable, you know, that is taking an unreasonable position, we have to now take and kind of, you know, give in to their position. Of course, if the person doesn't care, we can still fight it and they'll win, but you know, it's really not a win to me.
Yeah, I care. I care. Look, everybody, people out there really do. Attorneys are given a bad rap because there are attorneys out there who do some really dirty type deeds,
Mhm.
Like you said, they will squeeze or juice or churn a file. That is the wrong thing to do. In the long term, those people actually don't make a better living doing so, because eventually people catch on to the fact that this
Mhm.
is their MO, this is their thing.
Yep.
Um, and so, you want to be very, very cognizant of whether that's happening on your case. You want to be very cognizant of it. This whole thing about attorney's fees cuts both ways. You want to make sure that the work that's being billed and being charged on the case is actually being done, right?
Mhm.
And that's the case even in the event that you are the person who's ordered to pay counsel fees.
Mhm.
Because let's say that your spouse is looking for counsel fees and their attorney hasn't billed them in the requisite time. They
Mhm.
haven't billed them every 60 days like they're supposed to bill them. They've billed them every 6 months. Well, guess what? You just found out for not paying counsel fees to that
Right.
person,
Mhm.
you
Right,
know?
because right, I mean, I think it's the same in New York, but it's a reasonable counsel fee. So there is some entitlement to confirm that the counsel fee is reasonable. And if you're
Right.
not being billed,
That's unreasonable.
right,
And it's just not compliance with in compliance with our ethical rules.
right.
There's certain things that attorneys have to comply with in order to make sure that they get a counsel fee award. And that's something that you need to know both as the payor of counsel fees and as the person who is entitled to get the counsel fees.
Uh-huh.
Because if your attorney hasn't properly complied, you're probably going to lose that
Right.
request.
Hmm. On that point, also, I just want to make sure that everybody understands that even if somebody else is paying your counsel fees, even if that person is writing a check directly to your law firm, that person has no control over how your case is managed. Your
Right.
ex, even if they're paying for your fees, can't call our office and say, yeah, I'm paying your fee, so I want to make sure you're not making it this many phone calls, or I don't
Right.
want you to do this discovery because it's going to cost us too much money, or
Right.
anything like that. And by the way, you know, I actually have never had somebody ask for copies of the invoices that was paying, but I think it would have to go through the other attorney's office and be redacted.
Yeah, I agree with you, and that's what I do. I do that even in New York. We have an obligation to provide the bills when we're
Okay.
looking for attorney's fees, and so I always redact, and that's something that you really need to look at. Hopefully, your attorney is giving you the documents before they file them, and you always want to just double check. There could be a conversation that you had about your ex that you don't want anybody to know,
Mhm.
and if that conversation gets out there, attorney-client privilege no longer attaches to it, and
Right.
all your business is up in the papers that are
Mhm.
being filed with the court.
Exactly. And for anybody, redact is just essentially erasing or blacking out pieces of your invoices. So
Right.
uh, we want to be as thorough as possible when we're giving invoices. So we might say, had a phone call regarding, and then a little explanation. But if we have to produce those in court or to the other side, we're making sure we take off everything after regarding or even including I usually leave regarding just so they know that I'm taking off a conversation. I'm
Right.
not just randomly
Right.
redacting something. But yeah,
This hopefully has been a really informative show for
I hope
everyone.
so.
It's never easy to talk about money when you got to come out of your pocket with it. It's easy to talk about when you're trying to get the money, but not when you're
Yes.
trying to pay them. Now
Not
when you
when
have
you
to
have
pay.
to not when you have to pay it. And I feel like I don't know, I feel like we're a little more serious today because it's like we gave so much information.
I know, I know. Yeah, it's okay. I got purple hair though, so I'm not that serious. Like,
So
how could
how
I,
can you be serious with purple hair?
not unless you want to see me on the other side of the courtroom. That's a whole other
That's
story.
true.
I'm real serious.
Different setting.
Different setting, same purple hair.
Well, thanks everybody for joining us for this other episode of Undoing I Do with Stephanie in a Day. It's always a pleasure.
I had a great time. We'll see you next week. Don't forget to like our page. Like our page, comment, ask us questions. We enjoy interacting with you. Take great care and be safe.